Hello everyone and welcome to the L2 Construction Series video conference. Before we start, we would once again like to remind all participants regarding our house rules. First, please familiarize yourself with the Zoom app to ensure a smooth process throughout the whole conference. Secondly, please mute your mic to minimize interruption throughout the session. Third, if you have any question, please private message instead of public message to me, the MC. And then it will be forwarded to our speaker, and then it will be answered at the end of the Q&A session. Fourth, please be mindful of your actions on camera as all of us can see you on camera. Finally, please do not leave before the video conference ends to ensure a smooth procedure and minimal interruption. For recording purposes, we are not allowing any of our participants to record the session for today, and we thank you for your understanding. As for the slides, we will address it later at the end of the session. And we noticed there were many participants who was not registered yesterday, but we always welcome all participants to join in as the conference is about sharing all knowledges, especially all knowledges. And the reason why we want you to register yourself to us is because we would like to update you with the latest updates. So please do register yourself if you have not registered. Thank you. So today's topic is managing the impact of the COVID-19 outbreak on construction projects in Malaysia. Today is day 2 of the L2 construction series. We are honored to welcome our speakers, Mr. Loon, founding partner of Harrod and Lam Partnership, and Mr. Leong, claim consultant of MAC Consultant. Please join us and welcome our speakers for today. Thank you.
Thank you, Florence, our MC for the day. Good morning, ladies and gentlemen. As Florence has said earlier, this is day 2 of the session of the L2 construction series. The title today is a repeat of yesterday's, which is managing the impact of COVID-19 on construction projects in Malaysia. Now, as we all know, the Movement Control Order, or MCO, has already been implemented. And one or some of you might wonder where the power derived from. Now, the power is actually conferred by Section 11, Sub 2 of the Prevention and Control of Infectious Diseases Act 1988. It came into effect on the 18th of March 2020, and it has recently been extended to and remains effective until 14th of April 2020. Now, the effect of the MCO is that practically all businesses have to come to a halt, except for essential services. And at the time when the MCO was issued, a lot of us was actually not clear as to the scope of the MCO. So that's why the government and various departments, including the NSC, has actually issued various guidelines and clarifications. Now, of pertinence to the construction industry, there are 2 clarifications issued by the government. The first one was actually issued on the 18th of March 2020, and the second was issued on the 24th of March 2020. Now, in essence, what it says is that all construction and renovation works are generally described as non-essential services. There are exceptions whereby if there are ongoing works affecting safety and security and works which are deemed to be critical, then the contractor may continue with the works. Because in order for the contractor to continue with the works, they cannot just say that it's critical and therefore I, on my own, unilaterally continue with the works. They have to first get the certification from their SO or contract administrator. If you are on a government project, you have to get it from the JKR. Then you have to, with the certification, submit it to PWD and DOSH for them to assess whether or not it is critical works. Once it is considered or certified as critical works, then the contractor will have to apply to the relevant departments in the Ministry of Works or the state authority or the local authority, depending on the location of the site, to get the approval before you can actually continue with the works on site. Next slide. Now, what are these critical works? After the MCO and the clarification has been issued, the Ministry of Works have actually listed out a list of works which are deemed or considered to be critical works, and it includes slope repairs, refilling of potholes, etc., and also other works which will pose a danger if not completed. In essence, what it means is that there must be critical maintenance works, or certain works, if they are not continued, it would actually pose danger to the site or also to the people. So these works will be considered as critical because they need to be completed and they need to be continued. Now, as I said, that the continuation of the works is not automatic. You will have to follow certain procedure in order to get the relevant approval from the relevant departments of the Ministry of Works or the local or state authorities. As I said, all this will depend on the location of the project site. Now, the pertinent questions that arises from the MCO is this: what happens if the contractor continues with the work on site and these works are actually not considered to be critical? Now, the first thing, if they're called, it is not negotiable. Works must be stopped immediately. That is a must. Now, the second thing is also that the contractor may also be compounded with a fine of not exceeding 50,000, or liable to imprisonment not exceeding 3 years, or liable to both. Now, in addition, the contractor may also be liable to a fine of 1,000 ringgit per day if the offense is continued after the conviction. Where do these local authorities get this power from? It is actually under Section 70, Sub 13 of Street Drainage and Building Act 1974. Now, the next question that contractors would be asking at this moment is this: with the MCO and the works are not critical, I cannot continue with the works. Surely there will be a delay impact to the completion of the works. Even though there are certain parts of works which are deemed to be critical, there are also other parts of the works which you cannot carry on. So definitely it would have an impact on the completion of the works. There will be delay. Now, one of the things that you need to consider if you are a contractor facing such a situation, you have to consider, firstly, what are the events which have actually happened, which may potentially entitle a contractor to an EOT, or perhaps also to an L&E. Now, one of the events which is for sure, it has already happened. MCO has already been issued. That could potentially be an event the contractor may rely on to launch its extension of time claim. But as you all know, most of the standard form contracts, even though MCO or COVID-19 falls within the definition of force majeure, and force majeure becomes the ground for you to apply for an extension of time, the contract normally excludes the contractor's right to claim for loss and expense. And therefore, when these things happen, my advice is that you don't just jump to the conclusion and say that there's an MCO, I apply under force majeure. Be calm, think about what other events which may have actually happened. Is there a suspension or a stop work order issued by the local authority? If there is, then you perhaps also check the contract. Is it also an additional ground which you can rely on to claim for your extension of time? This is because each event entitling you to EOT entitlement might have also an L&E implication, meaning to say that if you rely on force majeure, you might not be able to get L&E. But if you actually rely on an event, which is a suspension order or a stop work order issued by local authority in compliance with the MCO, that may also allow the contractor to claim for loss and expense. So that's why the choice on reliance on which event to launch your claim is pertinent, is important. Furthermore, whether you also want to check there is an instruction issued by the contract administrator or an SO. If there is, then if the contract actually provides an additional ground for you to claim for extension of time, then you will again also check whether that is a better ground for you to rely on, because it may have an L&E implication, as opposed just relying on MCO and launch a force majeure application for extension of time. Right? If all these events depends on the location of the site, because I have seen various suspension order or so-called suspension order issued by the local authority to the employers and then pass on to the contractors to stop work at site. And the wording of each of the suspension order by the local authority might differ. And the wordings of this suspension order would have an impact on how are you going to launch your EOT claim under the respective contract. So you have to study carefully. And of course, at the end of the day, we just want to capitalize on all these events to maximize our contractual benefits that you can get. Now, as I said, even if you have all these three events happening at the same time, it would also depend on the wording of each contract for you to launch or pursue your EOT claim. Now, next, I have actually identified some of the things that the contractor should do, even though those events have already happened. There is an MCO, there is a suspension order issued by the local authority. There's also a suspension or stop work instruction issued by the architect in compliance with the MCO. Now, even if that happens, right, you don't take it as if it's like, oh, it's understood, I don't have to do anything. And you just assume that EOT will be granted to you. L&E would be entitled by you. No, it's actually not that simple. At the end of the day, even though MCO has already been issued, everything has come to a halt or a virtual halt. Then at the end of the day, you still have to look at the contractual requirements in order for you to ensure that you comply with them so that your entitlements under the contract is not lost. At the end of the day, your contractual entitlements is governed within the parameters of your contract. Therefore, it is important for you to follow these steps. First, as I said, identify the relevant events which have occurred, and then you look at the contract and try to maximize your contractual entitlements. The second thing, once you have already identified the relevant events which you can actually rely on to launch your EOT claim and or your loss and expense, then you have to consider to what extent in terms of extension of time and also the L&E claim, can I actually claim? For example, extension of time, demob and remobilization on top of the 28 days of the MCO. You can also claim for as part of the extension of time claim, right? And that would be an impact. Of course, this is just a simplistic general statement. It would also depend on whether the MCO has actually critically impacted the works that you have done, and you have to identify those critical works which have already been impacted upon. Now, and also you have to consider during this MCO, how are you going to prepare documents in support of your loss and expense claims? You are not actually just lying down here and wait for the 28 days to pass. You have to be ready now, identify what are these items of loss and expense that I can actually include in my submission later. Now, the third thing that you have to consider is this. Once you have a relevant event which happens that entitle you to time and also perhaps loss and expense, and you have also considered the extent of the claim that you can make and also consider about the documents in support of these claims, you must consider, very importantly, what is the contractual mechanism that has been put in place. Look at your contract. What are the condition precedent that you have to satisfy in order for you to claim for these entitlements? Is there a notification procedure? If there's a notification procedure, is there a timeline within which you have to file the notification? And for example, PAM, you have to file a notification of intention to claim for EOT within 14 days or 28 days after the happening of an event. And when the event ends, then you have to submit further particulars. If you don't follow this procedure, under the contract, it says that the contractor is deemed to have waived your right to claim for time and or also loss and expense, as the case may be. Now, on top of this condition precedent or requirements, I also have seen certain contracts like the infrastructure contract. I do not want to name which infrastructure. It actually provides a more stringent condition precedent. in terms of time, instead of 14 days or 28 days, they have actually imposed 7 days. And on top of it, there's a specific contents requirements. It is not enough if you just say that, oh, because of MCO, I'm claiming for extension of time. You have to provide a lot of other contents in order to make the notice to become a valid notification as envisaged under the contract. Like, for example, you have to set out what are the works which have been critically impacted upon. And you have to also demonstrate how much time as of this time you can estimate that it will be impacted upon. And then within how much time thereafter, you have to provide the particulars in order to support your claim submission. Now, all these contractual requirements must be complied with strictly in order to safeguard your interests. Don't be too relaxed about the situation just because it is a known event that MCO has been issued, and you just say that I will be entitled to extension of time. Nevertheless, do not take that attitude, because at the end of the day, your contractual requirements, you have to follow the contractual steps in order for you to make your entitlement. Next. The next slide is we are talking about the force majeure. Now, I have identified the 3 steps. Identification of relevant events. Now, just because there's an MCO, a lot of people actually come to tell me that I will be entitled to claim for extension of time under the force majeure clause. Now, one thing that is a misconstruction or misconception is this. Force majeure actually has no definite legal definition. Force majeure is actually a creature of contract. And the extent or the scope of the events that fall within the force majeure event depends on the wording of each contract. I have actually seen one particular contract that have exhaustive list of definition of force majeure, and it does not include epidemics. It does not include pandemics. So meaning to say that even if there is a COVID-19 happening now in Malaysia, you cannot practically find a ground for you to apply or launch your EOT claim. Because under the contract, there is no such definition to cover that issue. And that would normally be deemed as a neutral event, because the happening of COVID-19 has nothing to do with the fault of the employer. So if it is a neutral event, and if it is actually not set up in the contract, prima facie, I'm saying generally, the courts would actually take it that the risk is rested upon the contractor. The contractor will have to take the risk, right? Of course, there is a recent paper by a New Zealand academics which says that even though it is a neutral event, and even though the contract does not cover this event to entitle for an extension of time, and if this event has a significant impact on the time for the completion of the works, then the contractor may argue that time has become at large. But that is still subject to debate. But at the end of the day, the general rule is that if a neutral event is not stated under the contract, the court would deem that the risk is taken by the contractor. So that's why you have to look at the force majeure event, to the definition, to see whether COVID-19 falls within that definition. For example, the PAM form, if you look at clause 23.8a, the force majeure definition covers governmental and regulatory action. Now, that would include MCO. It has also includes the definition of epidemics, and that would include COVID-19. And therefore, very likely, if you are using the PAM form, if there is a happening of COVID-19 and an MCO, you can actually claim under the force majeure. Now, even if other contracts, they do not have specific description to cover this event, like the PAM form, then I would advise that you look for whether there is any other general description, like there may be a contract to only describe force majeure as an event beyond the control of the parties. If there is such a general description defining the force majeure term, then you might actually just say that, oh, COVID-19 and also MCO would fall within the force majeure event to entitle you to apply for an extension of time as well. Now, the next slide. Now, as I said, that don't jump on MCO alone, because MCO being a neutral event would normally exclude your right to claim for loss and expense under the contract. Look for other events, like for example, suspension of work or stop work issue issued by the local authority or even the contract administrator. Rely on it perhaps as a primary ground for you to claim for time entitlement and also for loss and expense entitlement as well. But do not give up on force majeure if you fall within that category, because you will always have a fallback position to say that I'm relying on the secondary ground without prejudice to my primary grounds on suspension order. Then you claim for extension of time. That is because even at the end of the day, if you fail to rely on your primary ground, you will have a fallback position to entitle to time. As a secondary ground for force majeure, at least if extension of time is granted to the contractor will be relieved from liability of liquidated damages. Now, that's all I have actually shared with regards to the identification of the events. I will pass the mic to my host partner, Hong Kit, to describe or elaborate further on the extent of the claim and how are you going to comply with the contractual procedure and also the documentation to substantiate your extension of time and also the loss and expense claim.
Yes, thank you, Loon. Good morning, everyone. This is L2 second day video conference. Yesterday, it was really amazing. We had a great turnout. We received quite positive feedback from the audience, and I hope to carry on in such a positive spirit today and further on. Okay, now I'm going to cover the practical guide to managing potential claim. As noted earlier, construction works are not essential services. Therefore, the only critical works that have been approved by relevant authorities are allowed to continue. So I would like to bring you through two different scenarios. Scenario one is when the construction works are not listed as critical works or have failed to obtain approval to continue. And scenario two is when the critical works have been approved to continue. Okay, let's look at the first scenario, which I think is the current situation for the majority of the construction projects in Malaysia now. If the works are not allowed to continue, what should you do? You don't call your other contractor friends to ask for advice to apply for extension of time or loss and expense, because most likely they are using different forms of contract which do not apply to you or having a totally different situations. The first step is go back to your own contract and see what the contract has to say. Before going further, I want you to understand the purposes of a contract are not only to set out contract price, duration, and scope of works. It's more than that. It is a mechanism to allocate risk between the contracting parties. When come to COVID-19 or MCO situation, most people would think only of a force majeure clause. It, however, may not be the only clause under the contract that covers this situation. Depending on the wording of the contract, a contractor may also want to look at suspension of work or the requirement to comply statutory direction, such as the current MCO to claim for extension of time and loss and expense. Here, it must be emphasized that the coverage and the effect of these clauses are subject to the wording used in the contract. To illustrate this, if a relevant event labeled under suspension of work has been expressly excluded neutral event, such as MCO, it then cannot be relied upon by the contractor for the present situation. A neutral event is an event that impacts on the completion date, but are not the fault of either of the contracting party. So locating the suitable or appropriate clauses are not the end of the story yet. Even the clauses cover for MCO period, this does not mean the contractor is automatically entitled to extension of time and or loss and expense. Do you know why? Because as my step 2 concerns, the contractor still have to demonstrate the MCO event has caused delay to the original completion date. Bearing in mind, not every delay is a delay to the completion date, and only delay that affects the critical path can be considered for extension of time. So how do we know whether a delay event affects the critical path or not? We don't guess, we don't assume, because there's actually a contractual instrument called baseline work program, which can help us to find out whether an activity falls under the critical path or not. Look at the slide here. This is a hypothetical work program that's created to show that there's an activity that not affecting the critical path. As you can see, even if the red activity starts after the MCO is lifted, it would not cause delay to the original completion date. Okay, I got a suggestion yesterday from the audience that I should give some explanation on what is a baseline work program. Okay, the baseline work program is a detailed view of how they will divide the whole works under a contract into activities, the duration of those activities, and the sequences of activities. The program should be practicable and realistic, showing when the contractor intends to carry out each part of the works and identifying the time required. For example here, a work program for building a wall would generally look like this. It has activities for bricklaying work, plastering work, and painting work. Here, the plastering work was supposed to be carried out during the MCO event, but it could not for obvious reason. When the plastering work were finally resumed after the MCO was lifted, as you can see here, the completion date would still remain the same. Therefore, the MCO period, though caused delay to the completion of the plastering work, but it did not cause delay to the completion date. The contractor would not be entitled to any EOD in this situation. Now, assuming there is clause that allows the contractor to claim for extension of time, and the MCO event is proven by delay analysis that it causes delay to the completion date, the contractor will be entitled for extension of time, provided the procedural requirement has been met, of course. However, this does not give the contractor an automatic entitlement to claim for loss and expense. Well, interestingly, most people I talk to assume that if you are entitled to time, then you are entitled to additional cost. This is untrue, as they don't come in pair naturally. It is very often that despite time for EOT is allowed, but cost for loss and expense is not. The contractor's entitlement to claim for loss and expense is subject to the wording of the relevant clauses. For example, if the clause has excluded MCO event, even though the contractor is entitled to time, it will not be entitled to loss and expense claim. This is the case in the PAM standard contract, where force majeure allows for extension of time, but not loss and expense. So, in the event the contractor is allowed under the contract to claim for loss and expense, I have listed out the potential claimable costs for your reference. For direct costs, commonly it has labor costs, plant and equipment, subcontractor costs, and also site overhead. The identification of direct costs is best achieved through site diaries or daily reports. Associate items such as vehicles and office space usually follow on if the individuals involved can be identified. As for indirect costs, it covers costs of head office staff and rental and utilities payment on the head office. These are the costs incurred by a contractor as part of its normal business operations. The entitlement of a contractor to recover indirect costs is not always easy to determine. Then we may also want to consider finance costs too, as a lot of contractors are operating on bank finances, such as the factoring loan, overdraft, term loans, and etc. etc. Now, we have covered all the steps necessary to make a claim under scenario 1. However, it still have to be properly prepared for the other party to assess the claim. You can't just dump everything into it and ask for a round figure like an estimation 20 million, 30 million, or 100 million. That's where it's a global claim. And it's not easy to succeed and not advisable to do so in such a manner unless there's really no other options available. If you fail to substantiate the claim, the probable consequences is this. Despite establishing the entitlement to the claim, you may be only entitled to a nominal amount. Here, there's a lot to cover for this. Due to limited time, we won't be sharing with you on the topic of how to prepare a claim. But we will be having a sharing session on this coming Friday, 11 a.m. on this same platform with another speaker about preparation of claim. We welcome you to join us if you are interested to know more about claim preparation. So we now arrive at the fourth step, which is mitigation. The idea of mitigation is this: even if the contractor is entitled under the contract to make extension of time and cost expense, the contractor must still take reasonable steps to minimize its loss, and must not take unreasonable steps that increase its cost. I give you an example. During the MCO, a contractor cannot include all its idling machines or machineries from his store and move all the machinery and the machines to the site just for the sake of claiming additional idling costs under the loss and expense. This would not be allowed. Right. The steps which I have just discussed are related to scenario 1 when the construction works are suspended. Just a quick recap. Step 1, go back to the contract to see what does the contract say. What can be claimed? Under what provisions? What are the condition precedents? And what are the procedural requirements? Step 2, whether the MCO affects critical activities on critical path. If it's not, the contractor has no claim. Step 3, identify the heads of claim and keep proper record to substantiate the claims. Step 4, always take reasonable steps to mitigate the loss. So claims are very easy. The claims are divided into 2 basic parts. Okay. Entitlement, which is the determination of whether the claim has merit or basis, and quantum, which involves a determination of how much money or time the contractor is entitled to receive. So it's entitlement, quantum. Step 1, my step 1 here deals with the contractual entitlement, while the step 2 deals with the factual entitlement. And steps 3 and 4 are relating to the quantum of the claim. We will now look at scenario 2, where critical works are to be approved to continue. If a contractor has received approval to resume works, it must comply with all directions set out by relevant authorities and contract administrator. Contract administrator is the architect, SO, whoever names under the contract to administer the contract. However, it must be emphasized here that it is not the type of situation where the contractor resumes different works under normal circumstances. The approval here is subject to the current situation, hence current directions issued by authorities. For example, the approval obtained may be subject to conditions like working hour or a specific method of the execution of the critical works. These conditions may incur additional cost or time for the contractor, and the contractor should look to the contract to see whether those conditions imposed have constituted to variation order. For example, the definition of variation under PAM contract is posted on the slide here for your reference. Okay. Therefore, once a contractor receives the architect's instruction to continue works based on the approval obtained, and when the approval obtained, for example, carries a condition of working only 3 hours a day, or some part of the site is closed, hence affecting the ordinary working hour and also working space of the contractor. In this situation, this may entitle the contractor to claim variation order. Of course, similar to the extension of time application, to effect a variation order, the contractual requirement must be strictly followed. All right, we have just covered the 2 possible scenarios. I would like to pass the mic back to my host partner, Wai Loon. Wai Loon, please.
Yep, thanks a lot, Hong Kit. We have so far covered what are the events which may entitle the contractor to an extension of time, or perhaps also the loss and expense. And Hong Kit has also covered the potential claim area, which is a variation order, if you are to instruct to continue with the critical works, but under different conditions. Yeah. So that we have covered that area. But there's also a related area that we would like to discuss about, which is the potential ground for frustration. Is the contract frustrated because of the MCO? Now, generally, a contract is said to be frustrated if there is a supervening event, which happened subsequent to the formation of the contract, whereby the performance of the contract has become illegal or impossible to perform. Now, if this event, MCO, has actually rendered the performance of the entire contract to be impossible or illegal to perform, then you can deem the contract to be frustrated. That is the general rule. But if the contract has already provided for such an event, for example, the contract has got an express clause to say that if there is a force majeure event, or if there is a COVID or a pandemics that happens, or epidemics that happens that actually prevented the works from carrying on, and there is already a risk allocation provided in the contract. For example, in most of the standard form contract, if there is already an extension of time clause covering this event, then it's very unlikely for you to say that the contract is frustrated. Because if there is a contract that covers such a situation, and the contract has already allocated risk amongst the parties, the court will normally enforce that clause and would not rule that the contract has become frustrated. Now, assuming in another situation, if the contract has no provision for such a situation, it's completely silent. And actually, the second requirement is also satisfied in the sense that the COVID-19 or the MCO has actually rendered the performance of the entire contract or the rest of the contract obligations to become impossible or to become unlawful. Then we can say that the contract is frustrated by the operation of the law. Then Section 57 of the Malaysian Contracts Act 1950 kicks in to say that what happens if the contract is frustrated. Now, the provision actually says that if the parties, one of the parties has actually incurred expenses to perform their obligations under the contract up to the date of the frustration event, and if that services or works have been benefited by the other party, for example, the employer, then the employer would have to compensate the contractor for the works done up to the date of the frustration. Now, when it comes to what is the reasonable reimbursement, the court would actually look at the evidence of the expenses incurred and also look at the terms of the contract as well. Now, I have briefly touched on the doctrine of frustration. Each contract would have different effect. It doesn't mean that when MCO and COVID-19 happens, it automatically renders a contract to be frustrated. In fact, in most construction contracts, you cannot say that the contract can be frustrated because of the effect, unless the effect, as I said, that is not catered for or dealt with in the contract, and the impact of the MCO and the COVID-19 has rendered the performance of the contract to become impossible or unlawful to perform. Now, I think the most pertinent area that we should consider at the end of the day, when the MCO is in place, what are the practical things that we should take note of? Now, on this particular topic, both Hong Kit and I have actually taken the liberty to interview or speak to some of our clients as to what they are doing now during the MCO period. And I have actually gathered some of the good points through talking to them that you might also find it useful, and you might also want to perhaps follow and implement some of the things that they are doing at the moment. Now, first thing is that, of course, as an employer or even a contractor, they have to ensure that the site is still safe and secure whilst the MCO is being in place, and they have to comply with the MCO strictly. Now, the most important thing is actually the workers. You also have to make sure that the workers on site that do not flout the MCO order, and also make sure they do not actually get contracted with COVID-19. Because if they do, or if one of the workers does, and all the other person who have been in contact with this particular worker will have to be quarantined. Now, even at the time when the MCO is lifted, because you don't take care of these workers properly and don't impose a strict regime upon the workers so that they do not expose to the risk of COVID-19, then if they are quarantined, even when the MCO is lifted, you will not be able to commence with the works. Now, some of the clients have even done a step further by having the workers to go through the COVID-19 testing as well, so that if there is one of them who has got such a virus, they can deal with it now during the MCO rather than later. This is to contain the risk.
Yeah, very useful sharing indeed from Loon. In addition to that, I think the contractor must also ensure all the machineries are in operational condition. as this can be done by having periodical check, inspection, and warm-up to prevent flat battery or flat tires. This is to avoid when the works resume only to find out that the machineries are not in a functional state. No one wants to be in that situation. Also during the MCO period, it is suggested that discussion and communication of management and planning team are to be continued on electrical forums such as WhatsApp, Skype, and Zoom, the one that we are using now, so that decisions can be made, directions can be given to the project team to keep the documentation in check. As we all know, contemporaneous reports are essential for preparation of claim. The contractor must also have to anticipate and plan for the resumption of works when the MCO is lifted. Finally, about salary reduction or deferment, it can only be done within the parameters of the government's directive and the law. As of the current directive, salary reduction or deferment can only be made with the consent of the employees. However, it is encouraged for the contractors to have open and honest communication with their employees to reach an agreement that would be perhaps beneficial to everyone in the long run in this very difficult period. That is it from me. Wai Loon, do you have anything to add from this?
Thanks, Hongkit. I actually have nothing further to add. I think it's timely now for us to perhaps ask the MC what are the questions that have been posed by the participants to her for us to answer.
Thank you. So we have collected all your questions throughout the conference session. Now our speakers will be addressing said questions in this Q&A session. Please once again welcome Mr. Lam and Mr. Leong. Thank you.
Thanks, Florence. I have already received the questions that you have directed to us, which have been posed by the participants. They are actually, honestly, many of them, just like yesterday, we did not actually have enough time to deal with each and every question. As usual, we will only pick the interesting questions that we can see at our first glance here and try to answer to the best of our abilities. Now, one of the questions is quite interesting here, actually. The participant actually asked that would the MCO period, because of the implementation of MCO, would also extend the defects liability period under the contract. Now, MCO, although it might be used as a ground for the contractor to claim for extension of time for the completion of the works, normally in most standard form contracts, they would not also provide for an impact of this kind of event to extend the defects liability period. Of course, if the parties had the foresight at the formation of the contract, actually cater for such a situation, then the contract terms would be followed. Now, in the absence of it, most of the time, the happening of an event just like MCO would not extend the defects liability period. Like for example, in a PAM form, right, they will have a particular month running from the issuance of the certificate of practical completion for the defect liability period to kick in. And then normally it will be in a number of months. And months has been defined in PAM contract to refer to calendar months. So it does not actually automatically gets extended because of an event happens in between. So then when you have a 12 months defect liability period, even though there's an MCO has been put in place in between, it will not, in my view, in such a situation, extend the defects liability period. If it's 12 months, it will still remain as 12 months. But of course, if the maintenance works or the rectification works are so critical or deemed to be critical, then they will have to get the relevant appropriate approval for you to continue with such critical maintenance works or rectification works at site. Hongkit, would you like to deal with any of the questions posed?
Yes, of course, Wai Loon. I have actually picked a very short question, but a very common one. Okay, the question is this: does the contractor have to continue to submit payment application for works done before MCO period? During the MCO period, works done before the MCO period, the submission, whether the submission should be submitted during the MCO period. Okay, the answer is this: I don't know. But I will try to answer based on my opinion and understanding. I think MCO restricts the physical construction works at site to avoid the spreading of the virus. but it does not freeze the operation of the contract, as the contractor still have to apply for extension of time and loss and expense and etc. As such, I think on the safe side, yes, the contractor still have to continue to submit payment application for its work done before the MCO. Here, another question then arises: how can the payment application be submitted since offices are closed? I think unless there is express contractual provision to disallow electronic submission such as email, then the payment application can be submitted by email and then follow up with hard copy after the MCO is lifted. That's it for me.
Okay, I think due to the constraint of time, we have actually overrun the program that initially fixed for 30 minutes. It's actually run to 40 minutes now. We will try to answer the other questions through other sessions or other channels as well. And again, thank you very much for taking the time for joining us in this L2 construction series. And we hope to see you in a future series. Now I will pass back the mic to our MC for her concluding remark.
Thank you very much. We would like to express our gratitude to all the participants for today's video conference. As mentioned by both of our speakers, today is the second day of the L2 video conference session. So, as you can see on the slide, there is a schedule, and then we have prepared a series of web seminars with our lineup of esteemed guests. So there will be more L2 construction series thereafter. For more information, please contact our friendly client support managers, Ms. Farah and Mr. Nizam, via WhatsApp or phone calls. So you can check out our social media pages on Facebook and Instagram under Mega Asia Training Academy. And you can scan this code for registration, because we have realized many participants have not registered themselves, and we welcome all of you to join us. However, by registering yourselves, you will get first-hand information from us regarding more updates for L2 construction series. So please do register yourself, and we can keep you updated. So once again, we would like to thank you and see you soon in our future events. Thank you.
I'll remain the slide for a while here then.
Yes, the slides will be here so that it's easy for our audience to screenshot it or take a picture. So do scan the code for registration.
Okay. Thank you, everyone.
Florence.
Thanks again. Hope to see you in our future L2 construction series webinar. Bye-bye.
Yes.
Stay home and
Thank you very much. Thank you very much, everyone.
Bye.
Thanks for joining.
Okay.
Thank you
Bye,
for joining.
Bye, Florence. Bye, Daniel.
Thank you. Thank you.
Goodbye,
Bye.
Daniel. Thank you, Mr. Leong, and thank you, Mr. Lam, our speakers for today.
Thank you, Florence.